Ya Arif, may it please the court, my name is Nur Shahira binti Muhammad Rafini, appearing as the senior counsel for the appellant to Peng, accompanied by my co-counsels Ahmad Izzuddin bin Ahmad Nazri and Asla Hanis binti Suhaizan as junior counsel for the appellant. Across the way, Nur Shafiqah binti Arifin as the senior counsel for the respondent, Deputy Public Prosecutor, and the junior counsel for the respondent, Nur Munira Fakira binti Abdullah. With permission, Ya Arif, I'll be taking 5 minutes to handle the first issue with regard to the defense of sudden fight, followed by my first co-counsel, who will be dealing with another 2 sub-issues under defense of sudden fight, while my second co-counsel will be dealing with another issue with regard to the defense of accident. Before I proceed with my submission, Ya Arif, I would like to inform the court regarding the matter facts of this case. Ya Arif, this appeal concerns the appellant who was convicted to death by the High Court of Johor Bahru for murdering the owner of a beauty parlour, the deceased. The appellant had intended to rob the beauty parlour when a struggle ensued between them, as the appellant took out a knife when he became enraged upon the refusal of his refund. At the same time, the deceased tried to wrench the knife from the appellant's hand, which caused both of them to suffer injuries and resulted to the death of the deceased. PW12 was a trainee beautician inside the closed room, became anxious after she heard silence after hearing the loud noise outside, and she came out and she saw the deceased lying dead on the floor. According to autopsy result, there were several injuries and stab wounds suffered by the deceased, in which some of it were described as defensive wounds, including one fatal injury. According to PW13, which is the friend of the appellant, he testified that at the time when he entered the premise, he saw the appellant stab at the back of the deceased with a knife while he was lying on top of the deceased. Appellant then instructed PW13 to get any valuable items before all of them fled from the scene. Appellant was then arrested on the same day, and the blood on the knife matched the deceased's DE. The fact that the killing was done in the course of struggle shall not preclude the appellant from raising the defense of sudden fight enumerated under Exception 4 to Section 200 of the Penal Code. Our client seek now to overturn the judgment given by the High Court of Johor Bahru that convict the appellant to death penalty. Ya Arif, my submission caters to the first requirement of the defense, which is sudden fight in heat of passion upon a sudden quarrel. Ya Arif, appellant submit that sudden fight had actually occurred at the time of killing, and the stabbing was done in heat of passion upon a sudden quarrel. To substantiate this issue, firstly, it was initiated by the commotion between the appellant and the deceased upon her failure to refund the appellant's money, and it escalated to a sudden fight when a struggle ensued between them. The fact that both of them were injured by the knife shows there is existence of sudden fight. To support this argument, I refer the court to Court of Appeal case in Public Prosecutor and Hamzah bin Yunus, 2017, tagged as Step 4 in Appellant's Bond Authority, paragraph 33, whereby the court accepted defense sudden fight and ruled that the fact that the accused was also injured indicates an intense situation, which raised a probability that the accused stabbed the deceased during the course of struggle to defend himself, which resulted in fatal injury. Similarly, in our case, the sudden fight occurred when the deceased tried to wrench the knife from the appellant's hand, and during the course of struggle, both of them were injured by the knife. And it's pertinent to note that the appellant did that in order to extricate himself. As applying the Court of Appeal decision, the stab wound done by the appellant shall be considered as a result of sudden fight. Ya Arif, we further submit that the existence of defensive wounds suffered by the deceased, as stated in the autopsy result, further strengthened the fact that the struggle existed at the time of killing. To support this argument, we refer the Court of Appeal case in Muhammad Azmirul bin Abdullah and Public Prosecutor 2015, tagged as Step 7 in Appellant's Bond Authority, paragraph 20, whereby the Court of Appeal accepted defense of sudden fight and further asserted that the existence of defensive wounds suffered by the deceased indicates a struggle exists, as it shows a close proximity between them, which caused the appellant to accidentally pull the trigger during the course of struggle and resulted in fatal injury onto the deceased. There's a similar position applied in our case, whereby the appellant had accidentally stabbed the deceased during the course of struggle, as they were in close proximity, and this can be shown through the existence of defensive wounds suffered by the deceased. With regards to stabbing in the heat of passion, we submit that the infliction of stab wound was done in a very short interval. To support this argument, we refer the Court of Appeal case in Haini bin Hamid and Pendawa Raya, 2003, tagged as Step 9, Appellant's Bond Authority at the highlighted part in paragraph I and A, whereby the court accepted defense of sudden fight and asserted that the stabbing that was done in a very short interval, no moment for cooling off, and absence of voice of reason is considered to be in the heat of passion. Similarly, in our case, during the struggle, there's no moment for cooling off. as the deceased tried to wrench the knife from the appellant's hand. At the same time, appellant tried to extricate himself from the deceased. And the stabbing was done the moment both of them fell onto the ground due to the act of the deceased who grabbed the appellant down with her. Thus, applying the Court of Appeal decision, the stabbing is considered to be in the heat of passion. Yarif, henceforth, we submit that the appellant fulfills the first requirement of the defence, which is sudden fight in the heat of passion upon a sudden quarrel. If I am no further assistance to this honourable court, I shall hereby end my submission proper.
Ya Arif, may it please the Honourable Court, with the permission, Ya Arif, I will be taking 5 minutes of the court's time for my submission. Appearing as a co-counsel, I intend to deal with the other two sub-issues under the defence of sudden fight. Ya Arif, unless there are any preliminary questions from the bench, I begin my submission proper. Ya Arif, begging the court indulgence, we humbly submit that there is no premeditation by the appellants when the killing and the stabbing was done without premeditation. The day before the incident, he had plans to rob the beauty parlour Advocate Indah. Ya Arif, I refer to the case of Public Prosecutor against Hamzah bin Yunus 2017 tag as tab 4 in the appellant bundles of authorities at paragraph 33 at the highlighted portion. May I quote, Ya Arif? In the Court of Appeal case, the learned judges held that there is no doubt that the accused had inflicted the fatal injuries, namely the stab wound, that led to the death of the deceased. There are two versions of the event that led to the death of the deceased, where it was said that the accused was the one who hit the deceased in an intent to rob the deceased, and the deceased then retaliated in order to save himself from the accused, and the fight ended up with the death of the deceased. Now, quoting from the same case, according to the evidence by the witness, it was held that there was an argument between the accused and the deceased, which started from a taxi fare. During the altercations, the accused had struck the deceased with a hammer, and a scuffle ensued between them when the taxi driver took out a knife. From the photograph it was taken, it can reasonably be said that there is a fierce scuffle between them. Similarly, in our case, the refusal of the deceased upon a refund had caused the appellant to withdraw his knife and shouting a refund. The quarrel continued when the deceased tried to wrench the knife from his hand, and a struggle ensued between them. Furthermore, Arif, PW12, who was a junior beautician who continues to work as usual as the appellant and the deceased entered the room, where she heard a loud scream and the voice of the appellant spoke loudly with the deceased. This shows that there is no robbery at the first place when he entered the premises, where it is witnessed by PW12 for the fact that she continues to work as usual. Later, PW13, who was a friend, entered the premises, where he saw the appellant on top of the deceased, where he had stabbed the deceased at the back. And the appellant then instructed PW13 to get any valuable item before they fled away. Arif, in the ensuing struggle, the appellant had to extricate himself, but it was not successful. It appeared that the appellant suffered an injury in the ensuing struggle, where it was said to be a defensive wound. His concern at the time was only to extricate himself from the deceased. To support this argument, Arif, I refer to the Court of Appeal case, Public Prosecutor against Hamzah bin Yunus, tab 4 in appellant's bundle of authority, paragraph 57, whereby the learned judges accepted that there is no premeditation on the accused, as he did not came prepared for a fight or had caused the deceased to a fight. So the weapon origin was unraveled, and neither the knife caused the injury was not the respondent's. Now, similarly to our case, although he brought a knife, his intention was only to refund his money, where upon the refusal, the fight broke out. Thus, he did not come with the intent not to fight, where it was due to the fact that he suffered injuries from the knife that shows the absence of premeditation on his part. Now, therefore, we submit that there is no premeditation on behalf of the appellant. Now, we seek the Honourable Court to extend our submission. We humbly submit that the killing and the stabbing was done without undue advantage or acted in a cruel manner. In our case, the appellant said that he too had suffered injuries of his body. May I refer to the case of Public Prosecutor against Hamzah bin Yunus, 2017 tag as tab 4 in the appellant bundles of authorities at paragraph 38. At the highlighted portion, may I quote, Yang Arif? In that case, the learned judges held that the respondent in this case was had not taken any undue advantage, where there was no evidence of brutal stabbing or assaulted the deceased multiple times. The respondent himself suffered serious injuries on his head and forearm, and was still bleeding from his wounds. Similarly, in our case, the main cause of death was the one of the two wounds to the abdomen, and they also injuries were described as defensive wounds. The appellant had not taken any undue advantage of the disease, as he tried to extricate himself, where in the struggle he was also injured by the knife. The cause of death where the appellant fell by accident, in which the knife had penetrated her abdomen. Yang Arif, therefore, we submit the appellant that the appellant had not taken any undue advantage and had not acted in a cruel manner or unusual fashion. If I am no further assistant to this honourable court, I shall hereby end my submission proper.
Yang Arif, may it please the Honorable Court, with permission, Yang Arif, I will be taking 5 minutes of the court's time for my submission. Appearing as the co-counsel, I intend to deal with the second ground of the appeal, where the learned judicial commissioner had erred in law and in fact for not evaluating the defense of accident under Section 80 of the Penal Code raised by the appellant. Yang Arif, before I begin my submission proper, does this court have any preliminary queries to be addressed? Much obliged, Yang Arif. My submission today will be substantiated with the element of defense of accident as enumerated in Section 80 of the Penal Code, tagged as step 2 in the appellant's bundle of authorities. First, it is submitted that the stabbing done by the appellant was accidental. In the light of definition referred in the case of R against Ong Chun in tab 10, page 101, it stated that the effect of an act which is accidental, not the act which caused the effect. Second, the concept of accident is delineated from in terms of reasonable possibility of a low risk of its occurrence. Similarly, in our case, for the first aspect, the appellant intended to extricate himself by pushing away anything that could harm him. Nevertheless, during the struggle, an unexpected fault happened, resulting in the stabbing. It can be inferred that the stabbing is the effect that was unintended by him. As for the second aspect, it is unusual and impossible for the appellant to foresee the risk of stabbing when, at the first place, he did not intend to kill or hurt anyone. The court should also take into consideration that the high amount of force inflicted to the disease was due to the nature of human being to save himself at that tension moment. The second element is that the act giving rise to the accident was not done with criminal intention or knowledge. In the case of public prosecutor against Hanin bin Osman, tagged as tab 13 in paragraph H and I, the Court of Appeal had decided that the act of stabbing the disease by the accused was accidental when the disease was never armed and further affirmed that if the knife was grabbed from the accused in the fight, surely he would have suffered cuts or laceration. However, in our case, the facts are not similar. Thus, the principle established in this case was not relevant to be applied in our present case. The first distinguishing fact is regarding the possession of the weapon. Even though the thieves did not have a total possession, however, we submit that there was an attempt to possess the dangerous weapon, and that is when the sudden fight occurred, resulting in the unintended stabbing. The disease had also scratched his face and his hand, resulting him to suffer injuries to several parts of his body, and the blood stain could be seen on the jeans he was wearing when he was arrested by the police. The second distinguishing fact pertains to the way the knife was shown to the victim. In our case, we submit that the appellant's intention to show the knife merely to frighten the disease, as there was no evidence as to the pointing to the knife to the disease. The third essence of this defense is the act of stabbing was done in the doing of a lawful act in a lawful manner by lawful means. By virtue of the case of Kong Po Ing against PP in tab 14, paragraph E, Federal Court decided that defense of accident was applicable since the defendant has been performing the lawful act of showing the knife to the victim. We submit that the court shall not conclude that the stab occurred during his act to rob the beauty parlor, what has been decided in the case of public prosecutor against Abdul Halid bin Allah, tab 15, page 127, that the defense is not intended for robbers who cause death while robbing their victims. In our case, even though the fact that he told his girlfriend his intention to rob before, however, he did not commit the robbery yet. It is totally different with the situation in the referred case, as there was an act of committing the offense of robbery when he asked money from the deceased. If the court would consider that the act of stabbing happened in the doing of showing the knife, we submit that his act was purposely to get back what he is entitled to, which is the treatment or the refund. If the court were to consider that the act of stabbing happened in the doing of extricating himself from the disease, it is also lawful, as we can see from the facts of the case. During the struggle, the appellant had no choice other than to save himself from being killed by the aggressive disease. The last element is he had exercised proper care and caution before the occurrence of the accident. We submit that the act of him only showing the knife amount to an act of proper care and caution. Therefore, he had exercised proper care and caution before the occurrence of the accident. Before I proceed to my concluding remarks, does this court have any concern that I may address? Much obliged, Yang Arif. Therefore, the appellant humbly seeks this honorable court to adjudge and declare that the appeal should be allowed because of the following reasons. First, the appellant did not have the intention to kill the disease as the sudden fight exists at the material time. Second, the stabbing occurred during the struggle to extricate the appellant from the disease was accidental. If I am of no further assistance or use to this honorable court, I shall hereby end my submission proper. Thank you.
Yang Arif, may it please the court, I am Nurul Syafiqah binti Arifin, appearing as the senior counsel for the respondent, which is public prosecutor, accompanied by my co-counsel Nur Munira Fakira binti Abdullah, where I'll be taking 7 minutes and a half to cater on first issue, while my co-counsel will cater on the second legal issue. Much obliged, Yang Arif. It may please the court, since the appellant had requested for rebuttals, we on the respondent side would like to ask the opportunity from the court to surrebut. Before I begin my submission, Yang Arif, I believe the facts given by the appellant are the material facts, and the respondent will apply the law based on the facts submitted by the appellant. Yang Arif, allow us to begin our submission. In response to issues presented by the appellant, I will be addressing our first legal issue, which is whether the learned judicial commissioner had erred in fact and in law when his lordship did not evaluate the defense of sudden fight raised by the appellant. The flow is, I'll be addressing the elements presented by the appellant in following order. First, upon sudden quarrel in the heat of passion. Second, the act was not premeditated. And third, the appellant did not take any undue advantage or acted in a cruel or unusual manner. Yang Arif, for the first element on whether the appellant had acted upon sudden quarrel in the heat of passion, I will rebut the appellant's submission first. Firstly, in the case cited by the appellant, which are Muhammad Azmi Robert bin Abdullah VPP, Haini bin Hamid v Pendakwa Raya, and Public Prosecutor v Hamzah bin Yunus, had been wrongly applied by the appellant. All of the three cases shows that there is no cool-off time for the accused to gain his self-control to constitute in the heat of passion. However, the appellant had missed the fact when the appellant indeed has stabbed against the deceased after the commotion using the knife, and there is a clear cool-off time period for appellant to between the struggle and the stabbing, where he should already gain his self-control by that time. Second, it was submitted by the appellant that the sudden fight must be sudden and not pre-planned. However, the robbery was planned by the appellant, and it should be anticipated by him that a commotion will happen, since the deceased will try to defend her life as well as her property. Third, in the recent 2020 Court of Appeal case of Jeffrey bin Tahil against Public Prosecutor, taken as Case 2 in Respondent Bundle of Authorities RBOA, at paragraph 1, page 10, where there were eyewitnesses that can actually testify there are exchange of blows. However, in our current cases, the appellant did not fail to bring more eyewitnesses that can prove there are exchange of blows, because even though the PW12 contended that she heard a verbal argument, but she did not eyewitness any exchange of blows. And even though there are injuries inflicted on the body of the appellant, it should be corroborated with more sufficient evidence, Yang Arif. To lay down this principle, I refer to the case of Chan Kui Fung against PP, taken as case 1 in the RBOA at page 17, where sudden fight means the fight is not pre-planned and must have exchange of blows, while heat of passion envisages the situation where the accused have experienced some degree of loss of self-control. Thus, the respondent believes there is a reasonable suspicion on behalf of the submission of the appellant, and the act of the appellant did not fit to the definition of sudden quarrel in the heat of passion as what has been rebutted and cited in the precedent cases above. Yang Arif, I will now move on to the second element, is whether the appellant act of killing the deceased was not premeditated. First, the appellant submit that the killing was not premeditated, as his intention coming into the beauty parlor is to rob the premise. However, the actual robbery itself had been pre-planned by the deceased, where he expressly stated a few times to PW20 that he wanted to rob. Second, the commotion or the fight happened was due to the refusal of the deceased to give back the refund that was entitled to the appellant, and the appellant only used the knife to defend himself when the commotion happened. Again, I would like to refer to the case of Jeffrey bin Tahil against PP, taken as case 2 in RBOA at page 1, where the killing was premeditated as he had searched the deceased after the work while armed with a knife. There is similarities of facts between these cases and our current cases because the fact that the appellant brought the knife into the beauty parlour shows that the killing was premeditated. Plus, the appellant also submit that there is no robbery taken place at the first place, which I believe this is not relevant to be discussed because the appellant indeed had robbed the beauty parlour. Yang Arif, to define the word premeditation, I refer to the case of T. Paramasparan anak lelaki Tani Gajalan against pendakwa raya tagged as case 3 in RBOA Act paragraph 45, page 11, where there must be an element of design or prior planning. To conclude, I believe Yang Arif, the appellant also failed to thoroughly prove on the elements of premeditation as the robbery, and the appellant act of bringing the knife shows that it was premeditated. Yang Arif, I now move on to the last element of sudden fight, which is whether the appellant did not take undue advantage and did not act in cruel or unusual manner. The appellant submitted that the last step was not the cause of the death, as according to the autopsy, the one that caused the death is the wounds at the abdomen, which due to the commotion. However, based on the case of Jeffrey bin Tahil against public prosecutor tagged as case 2 in RBOA at page 4, the fact shows that the appellant continued to attack by taking a piece of pipe but was restrained by PW5. This fact shows that the appellant act itself is sufficient to constitute the appellant had taken undue advantage and acted in a cruel or unusual manner even though he did not yet hit the disease. So, it does not matter whether the step is really the cause of death or not. What matters is the appellant indeed had stepped against the deceased, and this shows that he had taken undue advantage and acted in cruel and unusual manner. Yang Arif, I would like to refer to Lord Scarman when delivering the judgment of the Privy Council in Muhammad Kunjo against PP taken as case 4 in RBOA at page 5, where undue advantage means unfair advantage. And based on the principle above, the third element totally does not fit to the facts of the case. It is clear that the appellant had taken undue advantage and acted in cruel and unusual manner, where he again attacked and stabbed the deceased, which already weak and defenseless at that time. In sum, we submit and concur the decision made by the learned Judicial Commissioner in deciding the defense of sudden fight did not applicable to this case, as all the three elements had been failed to be fulfilled by the appellant. With that, I shall pass the floor to my co-counsel, Yang Arif.
Yang Arif, may it please the court, I am Nur Munira Fakira binti Abdullah, appearing as the second counsel for the respondent public prosecutor. I will be taking 7.5 minutes of the court's time. Yang Arif, in my submission, I will be addressing our second legal issue, which is whether the learned judicial commissioner had erred in law and in fact that this case should fall within the defense of Section 80 of the Penal Code for not evaluating thoroughly the accidental action raised by the appellant. With permission, Yang Arif, my submission will be associated with the elements of Section 80 of the Penal Code. Yang Arif, for the first element, we humbly submit that the incident occurred was not done due to accident or misfortune. The appellant submitted that the action of stabbing was merely accidental as the appellant and the deceased fell together, resulting in the knife to be embedded into the deceased's body. May I refer Yang Arif to the judgment of Judge May Ilwin in the case of R. An Chun, that as 66 in the respondent bundle of authority, whereby the first part of the definition, the respondent believed that it is contradicted with the testimony given by PW13 in the cross-examination. The appellant had stabbed the deceased as stipulated by PW13, which leads to the severity of injuries, which should be read together with the autopsy result, which resulted to 20 marks of injury. As for the latter ground, as per within the definition submitted by the appellant as an ordinary man shall acknowledge the consequence of stabbing the deceased, and in fact, the appellant was conscious of his action as he commanded PW13 to take valuable items prior leaving the beauty parlour. By implementing this justification, the court may be enlightened with the reasoning on the irrelevance applying the definition quoted by the appellant in regards to the element of accident or misfortune. For the second element of without criminal intention, the respondent believed that the removal of the knife sheath and the severity of injuries had illustrated the criminal intention on behalf of the appellant. Yang Arif, for the first justification, we refer to the judgment of Judge Court of Appeal Abdul Rahman Sabli in the case of Abdul Aziz bin Yong against public prosecutor, that as C5 in the respondent's bundle of authority at page 8 at the highlighted portion. It was deliberately mentioned that
if the accused had no intention to use the gun against anyone, he would have kept the safety pin to safe position at all times. Similarly, in the present case, the respondent believed if the appellant had no intention of killing the deceased, the removal of sheath is unnecessary. Moving forward to the second reasoning, severity of these wounds and injuries can be said as illustrating the criminal intention by looking at the wound as fatal in nature. In the referred case of law or D.R.D. Rasila against public prosecutor tag as C7 in the respondent's bundle of authority, page 17 at the highlighted portion, Judge Court of Appeal Abdul Rahman Sabri had the shoots on the vital organs of the deceased illustrated the intention of the accused. Thus, the respondent believed there is reasonable suspicion on behalf of the submission of the appellant in regards to the elements without criminal intention, and the act of appellant did not fit into the element of accident mentioned by Judge Court of Appeal Abdul Rahman Sabri in the case of Abdul Aziz bin Yong against public prosecutor tag as C5 at the respondent's bundle of authority at page 8 at the highlighted portion. Yang Arif, for the third element of lawful act, lawful manner or lawful means, it was submitted that the appellant tried to extricate himself from the struggle, and the appellant also contended that the actions was legal on the ground of self-defense. In the case of law or D.R.D. Rasila against public prosecutor tag as C7 in the respondent's bundle of authority, Judge Court of Appeal Abdul Rahman Sabri, page 14, delivered his judgment by saying that commission of robbery during daylight is regarded as unlawful act. It should be also distinguished with the action committed by the actioned man, as stipulated in the illustration of Section 80 of the Penal Code. Similarly, in the present case, the accused, the appellant, had committed the said offence of robbery during daylight together with PW13 and PW8. In regards to the appellant's submission of defending himself, Ya Arif, we refer to a case of Alandu anak lelaki Santana Sami against public prosecutor tag as C10 in the respondent's bundle of authority, page 5, whereby Judge Court of Appeal Hamid Sultan held the defence of accident and self-defence is contrary to the injury sustained by the appellant. This is further affirmed referring to the testimony given by the chemist PW6, whereby there was no indication that the appellant was hurt, as no blood from the knife being associated with the appellant's DNA. This shows the irrelevance of the reasoning of self-defense submitted by the appellant. To conclude, we believe, Ya Arif, the appellant also failed to thoroughly prove to this honourable court on the elements of lawful act, lawful manner or lawful means, as the robbery and the self-defense is contradicted with the testimony given by the experts. Ya Arif, for the last element of proper care and caution, the respondent submits that the severity and number of injuries sustained by the deceased prove that the appellant had not acted in good faith of proper care during the struggle. Next, the respondent would like to assist the Honourable Court by relying to the case of appeal Abdul Aziz bin Yong against public prosecutor tag as C5 in the respondent's bundle of authority, whereby Judge Court of Appeal Abdul Rahman Sabri held that if the accused involved in an accident, he should have asked for medical assistance. Similarly, in the present case, the appellant did not intend to search for medical assistance. However, he also commanded or instructed PW13 to take valuable items prior leaving the beauty parlour with PW8. A reasonable would not be injured such a way if the man is merely being shown a knife, and the knife should not be used during a verbal argument. The injuries sustained by the deceased were contradicted with the submission of the appellant. We believe if the appellant truly considers the element of proper care and caution, thus the medical assistance should at least be considered by the appellant. Ya Arif, now I proceed to the burden of proof, whereby for the first legal issue, we may refer to the case of Ansang bin Rasad against public prosecutor tag as C12 in the respondent's bundle of authority, whereby the judge held that an accused improving the defence of exception of Section 300 of the Penal Code, it should be read together with Section 105 of the Evidence Act 1950, whereby the burden of proof is vested on the appellant. For the second legal issue, we may refer to the case of Abdul Aziz bin Yong against public prosecutor, whereby the Judge Court of Appeal Abdul Rahman Sabri at page 10 tag as C5 in the respondent bundle of authority held that Section 80 of the Penal Code should be read together with Section 105 of the Evidence Act 1950 in showing the burden of proof is vested on the accused. Ya Arif, based on the submission, the respondent had demonstrated that the defence of Section 5 under Section 4 of Section 300 of Penal Code and defence of accident under Section 80 of the Penal Code did not apply to this case. We humbly seek this honourable court to dismiss the appeal due to the unfulfillment of the elements of those defences. Wherefore, the respondent humbly and respectfully prays that this honourable court of appeal dismiss the appellant notice of appeal dated 12 July 2020 with cause. If Mr. Arif has no further question, that concludes my submission.